and welcome to another session of Litigators Corner. I have the distinct pleasure of being with Alan Tavelman. He is a litigator and trial lawyer at Liberty Bell Law Group. There aren't a lot of attorneys I call for advice, but when I need advice, I always call Alan. Alan is a former LAPD homicide detective, and he owned his own law firm, and now he is a senior attorney and litigator at the Liberty Bell Law Group. Alan not only handles criminal defense, but a lot of civil defense cases. And he is very knowledgeable in a lot of areas of the law. And I think that Alan has a lot of wisdom and knowledge that we could all learn from. Alan, how are you this afternoon?
I am doing great. Thank you very much for the kind words in the introduction.
Tell us a bit about yourself and what you do.
I am a retired law enforcement officer. I was lucky enough to spend some time in Southeast Los Angeles working the homicide, working the streets. I went to law school while I was in the detective bureau, and it was a quite interesting experience being in law enforcement and then going to law school at the same time. You actually get a complete different thinking mechanism, and your mindset changes, and you feel it after around the second year of law school. Once graduated law school, I put in my papers. I retired from law enforcement and actually got involved in civil law initially with employment discrimination cases. And quickly it kind of dovetailed into criminal defense. And now I am a senior litigator at Liberty Bell Law. I do both criminal defense as well as the high-profile civil cases that we handle.
And Alan, you've been in the courtrooms. A lot of us haven't even gone to court except by Zoom. You have actually been in the courtrooms during this COVID-19 pandemic. What have been your experiences going into court? What is, like, for example, what is the mood? What do you see from judges? How fast did you see this change?
I've noticed an actual change in the atmosphere of the courtroom itself. There's a distancing amongst all the people in there. And I don't mean social distancing, I just mean in terms of conversation. And everybody's trying to kind of find their own way how to go about doing the job. I believe that everyone's trying to do the job, but they just aren't really caught up with technology yet. We're also finding that there's some issues with constitutional law in regards to the criminal cases and the ability for the defendants to be actually present in the courtrooms for the preliminary hearings. We have no trials whatsoever, which is understandable. And my fear is that the system may be so impacted that they cave into a Zoom trial scenario and they try to make it into a constitutionally I guess, within the Constitution, I should say, by saying that you are technically present within the courtroom and you technically can face a witness against you.
And do you think that meets the Confrontation Clause requirements?
I do not. I don't believe that it meets the standard, because what happens is you want an opportunity to see the witness, to actually see the mannerisms, have eye contact with the individual, see if they're actually fidgeting. And you also want the jury to see that, because they size people up by the whole picture and not just a small little picture that we see on a phone or on a computer box, such as Zoom. So I noticed that, people are wearing the masks and some people are wearing visors. And there's just a standoffish appearance, kind of a heavy feeling actually in court.
And how do you think these delays as a whole are going to affect the system? I'm concerned. I mean, these are really getting backed up, and we have new cases. We have new cases coming in weekly, and we're fortunate in that regard, but just the delay after delay after delay. I know that you and I talked the other day that I don't think they're having criminal trials this year, and I know they're not having civil. They may have hearings, but I don't think they're progressing much further than that. How do you feel about that? What that's going to do to not only our criminal system, but our civil system, and the ability of anyone to get into court?
That's a good question. And I believe that prior to the closing of the courts, our system was just clogged, both civilly and criminally. And now with the closing of the courts, which is understandable, there's a tremendous backlog. I just set a trial for early 2022. And as far as the civil cases go, most judges I'm running into aren't actually even scheduling trial dates, or they're doing it so loosely, knowing that we just don't know when courts will be fully open again or if they're going to close again. We're in a uncharted territory. This hasn't happened before, at least not in the last 100 years. So it's an unknown.
And with what are your experiences in working with clients? I mean, some of my clients have accepted it pretty gracefully. They're like, no, we understand. Other clients are like, no, I want to get into court right away. I want to face these people. A lot of them are looking into ADR. What have you, I'm sure it runs the gamut, but what would your comments be about, without waiving confidentiality, your experiences with clients to have any kind of access to the legal system, even if it's not in the courtroom?
Actually, it's very interesting because coming from both a civil as well as a criminal defense aspect, civilly, I think it might actually benefit the court system because it could push litigants towards the ADR process. And you can't have mediations, albeit it's unusual to do through Zoom and other types of media. So I think that the length it would take to actually go through the whole civil procedure and the jury trial, they're talking 2-3 years, and I don't think clients are willing to wait that long. There's another aspect that I've actually come into play. Some of my clients have actually looked into actually having private retired judges litigate the cases, which is very expensive, but cuts through the delay. So I think in terms of civilly, if the system uses and maintains the approach they have now, such as technology, it could benefit in the long run and push litigants toward the ADR system. However, the other side is the criminal. In criminal law, my clients, which is understandable, many of which are actually in custody with bail that has set so high that technically it's almost impossible for them to reach that number, $2-3 million in bail. They are very frustrated with the system. We get right up to the preliminary hearing, and then things are really frozen at this point because we can't get to a jury. The DA's office has not quite gotten to the point where they're relaxing some of the plea deals to the point where one of the clients may think about taking a plea opposed to taking it to trial. So it's very frustrating for some individuals who have been waiting months to get to a jury trial.
And their families and people they work with, and witnesses probably too, who are like, have to hang around and be available.
The witnesses and the victims who want to seek justice and have the ability to tell their side of the story. It's a system that was clogged to begin with. And as of no fault of any particular branch, this is what we're dealing with. We had to close the courts. I agree with that. I don't like it, but I think that people's health and safety is at the forefront. I believe the courts made the right decision in terms of suspending certain rights, but there comes a point when you have to actually litigate these cases or have them go before juries. They can't stay in custody for years without having a trial. That's unconstitutional. And that's not within our system. And that's not what the founding fathers had in mind. We have a bail system, but the bail system is so outrageous at this point that the wealthier individuals can actually make bail, and most of the population can't.
So they're essentially being held in captivity indefinitely, not knowing if they're ever going to get a day in court, or may be forced into taking a plea just to get some resolution.
That is 100% correct. And in terms of requesting bail reductions, there's no give on that as well, based on what they say is threat to the society, and the factors that they go down when they consider the bail deviation or the bail reduction. I've also found that if I have a client that can make the bail for some reason, the next day there's a bail deviation, and when we get to court, they jack it up, and then they're actually taken into custody. That's happened about 4 or 5 times. They're actually taken into custody again. So the system needs to actually relax a little bit and look at the big picture, which is constitutionally, these people either need to be tried or released on bail, reasonable bail.
I know that we had a conversation, this is related. I think most litigators, whether you have a criminal defense or civil defense or plaintiffs, come into contact with police reports, whether it's an insurance claim or an auto accident, or if it's like what a lot of work we do with, like defamation, for example, and employment law, defenses of assault and battery, things like that. I think most civil and certainly criminal litigators come into contact with police report. And I know that we had a conversation the other day about there are things that may be in a police report and may not be in a police report that can be very beneficial to your case. And what are your tips for a lawyer who maybe doesn't have a lot of experience with the criminal system, because they don't have your background with homicide, and I know you worked vice briefly, or criminal defense, when a civil litigator or someone who doesn't have a lot of experience is looking at a police report and they look and they go, this doesn't really help me. Are there tips that you could look at that police report and maybe get evidence or ideas of where to go with your case?
Yeah, it's very interesting because it actually depends upon either the crime or the civil action. And quite often, I have found, and yeah, I may have an edge because of my background. It's not as much what's in the report. It's what isn't in the report. Some of the times you take a step back and use your common sense. Sometimes you actually have to see, in your mind, diagram it out in your mind to see if it makes sense. There's timelines that I have found don't match. Just had a scenario where I was able to get the evidence thrown out because the search warrant was bad. And when I took a look at the warrant, when it was produced and discovery, I read what was written, and there were a couple words that sounded like the individual who was there is not the individual who signed the affidavit. And then I took a look at the signature itself and matched it against one of the reports, one of the police reports, and I noticed that the signatures were nowhere near the same, which got me to thinking, especially with the circumstances that we have now, doing everything through technology. What happened was true. We had one officer who did speak to the officer at the scene and wrote down what the officer said and then signed it, but used that officer's name. Now, you can't sign, as everybody knows, somebody else's name under penalty of perjury because it's not that person. What was very interesting is, which is a true statement, all they had to do is indicate that they were informed by the officer at the scene that they've got, 15, in this case, it was 15 years on the job. And the judge would have read the affidavit and the warrant would have been valid. But in this case, he signed the name of his partner, who actually was still at the hospital with the victim. And you can't be in two places at once. And if you look at the time that it was signed, and then you look at the time on the MDT, which is the computer screen, as to where that vehicle was, they couldn't have been in two places at the same time. And that's kind of what I was looking at, what wasn't in the report. The time that one officer got to the hospital versus the time that the warrant was emailed to the judge for signature. You can't be in two places at the same time. And, fortunately for my client, we did get the evidence excluded, and I think it was a valuable lesson actually for the two detectives, and I'm pretty sure they won't make that mistake again.
No,
So
I'm sure.
You got to be aware of what you're looking at. Sometimes it's not a legal issue. You just use common sense on the reports.
Has it been your experience more often than not? I'm sure yours were thorough, but is it in your experience sort of across the board, if you can make a generalization, do you think more information or less is included in a police report?
Substantially less. Substantially less.
Because I often come across these things looking at, I think that's a big thing people miss. I often get, well, I told the police officer this. I don't know why it's not in the report. And so you often have these situations where, like, I told them that, and then the officer, with good reason, doesn't know later. Say, I don't know. I just took the report. We're busy. I sort of remember this person, but I don't know. How would you attack something like that?
Well, I don't. Most of the time, I would say that the officers are not intentionally omitting certain facts. They're pretty much rushing to get the report done and move on to the next call.
Sure.
One of the things that I have found invaluable, both in civil law as well as in civil litigation as well as criminal law, is the body-worn cams by the officers. Because I've noticed that in a lot of reports, especially in criminal, they will paraphrase what my client said or paraphrase what the victim or witness says. And recently, based on what one of the witnesses said, unless he was looking through a wall, he could not have seen the individual come out of the garage door. Now, based on the report, it indicated that he observed the individual exit the garage door. But what happened was, based on the body-worn video during the time that it was going, is he saw the guy exit the yard where the garage was. And that's the difference between a burglary, a trespass, or a complete dismissal. Mm-hmm. So body-worn video is very important, both on civil as well as the criminal aspects.
And is it your experience that they're wearing it regularly? I know that they're monitored. I don't know how stringent they are about that, their body cams.
Nowadays, they are very strict on body cams. When I was on patrol, we never actually had body cams. But now I think they're invaluable. And I think it benefits both the police and the public as well. For whatever reason, things that could be said wouldn't be, altercations that may take place don't, and I think it's a win-win situation with the body-worn videos. There is a little thing that I did want to make mention of, and it's not a intentional act. When an officer gets out of his vehicle to activate the body-worn video, there's a brief delay in the audio portion, not the video portion. So if you do get a tape and you think that maybe they didn't turn the sound on purpose, if there's no sound more than 20 seconds, then they probably did. But there is a delay in the audio. So just keep that in mind.
So it could be up to 20 seconds. That's been your experience?
The longest I had was, I think, 17. I monitored from the tape, 17 seconds.
That's it. So if anything you're seeing, you have to sort of be able to read lips or hope you can see it. You're getting a couple
Yeah, yeah.
and the going forward, we're going to at some point we're going to have trials. I know that the litigation section is working with in connection with San Francisco. The Bar Association put on a series about my first COVID trials. A lot of the lessons that they're going to have are going to be from court appearances in criminal matters. What do you think are going to be the biggest challenges and obstacles for the first trial? I mean, the bench trial I would think would be a little easier, but for example, our first jury trial is going forward in this COVID age, which looks like it's going to be prolonged.
I believe that they're going to have a problem trying to sit jurors. Many of our jurors are older individuals, and they are in the target zone and very susceptible. The social distancing. Went to court the other day, and they had 3 available seats per row that you could sit in. So you could only get 25 people maximum in the court, and that's including attorneys as well as court staff. So that's going to be an issue, seating witnesses and juries in the social distancing requirements.
Do you think in this day and age that a person can ever really get a jury of their peers? Because you're going to have a lot of people because of COVID are going to be out. Elderly, people of a certain age range are at higher risk. Anybody who's had an autoimmune or any kind of respiratory problems, anything like that, you're going to have a lot of people, I would think. Most people don't want to be on juries. I mean, some of them do. Criminals probably a little more interesting, but you already have an issue where you have difficulty getting juries often. They don't get paid very much. They're taking time off work. They've got other things to do. There may be a child care issue. So do you think people in this day and age are really going to be able to get a jury of their peers? And do you think that will not only affect verdicts, but appeals?
I think that the system does its best, but I don't think that you get a jury of your peers. But I don't really think that that's based on the current medical situations. I just think it's very difficult to seat a jury. Very few individuals that, I believe it's very few individuals that can actually afford to take off work. Unless your employer pays you, if you're like a postal worker or some type of medical care, they do cover it, as well as retired individuals. But it's very difficult to get a jury of your peers. But it always has been. There's political issues, racial issues. So I think that in and of itself makes it a difficult situation.
And what advice, as someone who's been in the courtroom, because a lot of us haven't, I have, but didn't like the quarantine afterwards, but I have been in court. What advice do you have for people going into the courtroom now? Because I know that we talked about there's even the delays having your case heard. There are delays with technology that sometimes doesn't work. What is your advice to someone going into court for the first time? Because some people are this COVID.
I think it's something that's called patience, and that's extremely difficult because we want to get in there and get out, and everybody wants to be the first couple cases called. The problem is that they have a system that has to comply with certain safety, medically safe requirements, as well as the sheriff's department bringing in the in custodies. They got to call certain cases before others. A lot of the times they take in custodies versus other cases first. So be patient. Bring a mask. They are really clamping down on that right now. That's something that we all should do, I believe. Not that we want to, but I think we need to. But as far as the civil trials, the judges on the civil bench, they understand. They know the system is substantially clogged. They are setting cases as quick as they can. But if the courts are closed, they're very limited and their hands are tied as well. I think everyone just has to be patient and understand that it's going to take a while. This is the new normal, at least for a while, at least till next year.
It's the foreseeable future until we get a vaccine.
Correct. But not just a vaccine, but a vaccine that that works and that people actually trust. Because once that happens, I think we'll get back into the rhythm, and things will definitely get back to the normal, and we'll be able to take care of the situations that we need to take care of.
Do you think we're ever going to go back into courtrooms the way we used to? I don't think we are. I think a lot of these are going to be handled by Zoom, and I think that's going to be the new normal permanently. What do you think?
I hope so. I think that they kind of loosened up a little bit. We all love the court call because that allows us to kind of do it over the phone. I think Zoom definitely will step up, or those type of programs like Zoom. I'm hoping that in the criminal aspect of it, they allow similar scenarios. But right now, it appears that the district attorneys can appear Zoom, but the defense counsel have to show up. So it's kind of unfair, but
it is
understandable.
Well, Alan, thank you so much for making the time today. This was so informative and is always interesting, and we appreciate you being so generous with your time and your legal mind. And we are very happy to have you as one of our interviewees for Litigators Corner.
I thank you very much for the time, and I'm always available.
Thank you, Alan.
Take care.
You too.